So, are all California budget trailer bills protected against a referendum challenge? Some Capitol observers have posed the question whether budget trailer bills in the California legislature are shielded, if you will, or protected from a referendum challenge. Now, the answer to this question has not been addressed by the judicial branch, but we can certainly make an educated guess. And let's consider a few points. By way of background, Article 2, Section 9A of the state constitution provides that the referendum is the power of the electors to approve or reject statutes or parts of statutes, except urgency statutes, statutes calling elections, and statutes providing for tax levies or appropriations for usual current expenses of the state. In addition, Article 4, Section 12D and 12E describe appropriations from the general fund of the state and appropriations in the budget bill and in other bills providing for appropriations related to the budget bill. And Section 12E2 defines other bills providing for appropriations related to the budget bill as consisting only of bills identified as related to the budget in the one budget bill that's passed by the legislature by actual number. And so it's this clause that sets the stage for budget bills junior and trailer bills. Now, under Prop 25, which was adopted by the state's voters in 2010, the budget bill and other bills providing for appropriations related to the budget bill only require a majority vote for passage on the Assembly and Senate floors. And of course, they take effect immediately upon their enactment pursuant to the Constitution. Now, does this mean that these bills are not subject to a referendum? More specifically, the question is because a budget trailer bill contains an appropriation, even sometimes a very nominal amount, it's tied to the budget bill. Do these trailer bills fall within Section 9A and therefore are not exempt, or excuse me, that they are exempt from the referendum process itself? Well, unfortunately, the term appropriations for usual current expenses of the state is not defined in the state constitution nor in statute. Now, while this term has generally been interpreted to mean funding for state government, obviously not all expenses of the state are usual current. And so it may be unclear whether every budget trailer bill is actually protected from a referendum challenge. So, how have California courts viewed this exemption from the referendum authority granted to the people in the state? Well, in a recent case, Wilde versus City of Dunsmuir in 2020, the Cal Supreme Court considered whether municipal water rates were exempt from referendum. And the court said, but to prevent the referendum process from disrupting essential governmental operations, the Constitution exempts certain categories of legislation, including statutes providing for tax levies or appropriations for usual current expenses of the government. Under this language, a court's determination would rest upon whether a budget trailer bill is needed to ensure essential governmental operations would not be disruptive. So the High Court, in its Wilde decision, said the question in this case is whether this exemption applies to measures being setting municipal water rates. And the court said, we conclude the answer is yes. Municipal water rates and other local utility charges may be challenged by other means, but they are not subject to referendum. California's High Court in Wilde went on to say, we have previously explained that one of the reasons, if not the chief reason, why the Constitution accepts from the referendum power acts of the legislature providing for tax levies or appropriations for the usual current expenses of the state is to prevent disruption of its operations by interference with the administration of its fiscal powers and policies. And it was quoting the Geiger case, which was a Cal Supreme Court decision. They went on to say in the Wilde decision, referendum, we have explained, poses a distinct potential for disruption that sets it apart from the ordinary legislative process. To give voters an opportunity to propose referendum measures, all legislative enactments subject to referendum must wait some period of time, generally 90 days, before they take effect. With this additional explanation, a court might likely consider the budget bills junior and even budget trailer bills to be part of the state government's administration of its fiscal powers and policies, and therefore should fall within the constitutional exemption from the people's referendum power. The legislature and administration would certainly argue strenuously, in my mind, in a court of law that a referendum against any budget related bills would disrupt the essential operations of the state. In another case, Rossi versus Brown, a 1995 California Supreme Court decision, they similarly stated all of the exemptions for urgency statutes, statutes calling elections, and statutes providing for tax levies or appropriations for usual current expenses of the state are for measures having special urgency, a delay in the implementation of which could disrupt essential governmental operations. For this reason, the court explained that if essential governmental operations would be seriously impaired by the referendum process, the courts, in construing the applicable constitutional and statutory provisions, will assume that no such result was intended. The justification of the exceptions to the referendum power had been consistent for nearly 70 years. Going back to an earlier decision often cited regarding limits on the people's referendum power, this is Geiger versus Board of Supervisors of Butte County in 1957. The Supreme Court said one of the reasons, if not the chief reason, why the Constitution accepts from the referendum power acts of the legislature providing for tax levies or appropriations for the usual current expenses of the state is to prevent disruption of its operations by interference with the administration of its fiscal powers and policies. So, as a result of these court decisions, it would appear that all Budget Bills Junior, and budget trailer bills containing an appropriation would likely not be subject to a referendum because a referendum would be viewed as possibly creating disruption of the state's operations and would amount to an interference in the state's fiscal powers and policies. Now, this does raise in my mind at least one interesting question. Could a referendum, which of course, as we know, can be pursued against an entire statute or just part of the statute, could be used to not address the appropriations piece of the budget trailer bill, but instead the statutory language of a budget trailer bill that contains an appropriation? Now, if this course of action were pursued by a referendum, the issue that a court would have to decide is whether simply having the appropriation in the trailer bill can be viewed as part of the statute and not be subject to the referendum, and instead allow the actual statutory language in that trailer bill to, in fact, be subject to a referendum.